So let me start today because it's already very late. And dear, good evening to all of you. And today, as you know, is the last session for me. I thought I would do more interaction and talk to you. But then there was a request on patent and whatever information I had. So I thought, let me share it with you. So I'll go through the patent thing, that how you can go ahead and do the patent. So before going for that, I also want you to know that the importance of patent, especially for the students and professionals in the field, any field, whether you are in education field, you are in a IT sector, you are working in any of the thing. If you have patent in your name, you have a better opportunity and you have a better visibility in the world of business. So that's the reason, as an academician, also we encourage students to go for patent if they have any new idea. And so the problem what occurs is that the students feel that it's a very tough process. What should we be doing it? How do we go about it? So somebody requested me last time that why don't we have a session on patent filing, especially design patent. Excuse me. Sorry for that. So I'm going to share. Just give me a few seconds.
इनके नाम पे पेटेंट्स बहुत है. शेयर अराउंड 17 to 18 पेटेंट्स. उसकी कमाई अलग है. 17 to 18 पेटेंट्स हैं. पेटेंट मतलब सर एक प्रोजेक्ट जो जिसकी फंडिंग देते हैं, गवर्नमेंट फंडिंग देते हैं, प्राइवेट फंडिंग देते हैं.
So students, let's go about patent procedure. So I'm just going to keep simple this session, and later on I will be keeping whatever time is left for the question and answer session, or maybe interaction session, because this will be the last session. And I would like you people to ask, or I can interact with you, and then we can discuss certain thing. You can share some information also with me. So let's go about it. Now, basically, when we talk about patent, there are actually several intellectual property in different bodies of law that protect that particular intellectual property in different country. So, for example, if you have a name brand like Apple or Google or Microsoft, you use a trademark law to do that. For example, in our college also we have done a kind of a trademark on our festival logos and all. So you can do a trademark on that. Then if you have a work of authorship, like you have written something and that you want, like a story, a poem or something like that, you may have, or a picture, you have an art you have drawn. So you can have a copyright law. So if you have a secret recipe, like most of the restaurants which are generation to generation old, they may have certain kind of secret recipe, like Coke syrup secret recipe. So you can have a trade secret law in that, and you have a right that enable you to make money by that endorsement. So but these are something which we are not talking, because we are basically talking about idea, and idea developing into product or services or process. So what if you have an idea? So if you have an idea and that idea can turn into a tangible thing, I am saying tangible. See, copyright and trade and all these trademark or GI, geographical indication, all these are most of the time intangible. But if you have to protect a tangible product or service or process you have developed, in that case, we go for a patent. Okay, we protect that particular work by patentship. Okay, so a patent. So whenever you have an idea, you are probably realizing that you have an idea. The trademark law might help you with the name on it, right? you can exercise. Copyright law might protect you in the final expression of it. For example, if you're publishing it or something like that. But it is a patent law which actually protect that idea. So patent law is an area of IP law that will protect your invention, okay, and keep that invention with you so that you can later on commercialize it. So patent law protect your idea by granting a monopoly on that idea for 20 years period. So now we have to also understand which are the idea which can be protectable or patentable or which cannot be. So let me talk about the kind of idea that can be protected under the patent law before we go for that. So in order for to, each one of us have different ideas. When I normally talk to my students, I always say that, idea comes from the problem around you. If you find any particular problem around you, like for example, when the Sony founder, he was walking with he was traveling in a train with his daughter. His daughter said immediately that, I'm getting bored. I wish I could have a portable music system to listen to music and, pass my time. And the person got an idea that can we have a portable system where you can carry music with you? And then Sony came out with a device called at that time, it was Walkman. Then Apple saw that, and Apple said that the Walkman has certain kinds of weaknesses, like you have to carry the cassette with you. It is little, heavy in size. What if we have a very small device in which you can download music of any number and carry with you? You don't have to carry extra baggage for that. So they came up with iPod. Those are innovations, not invention, right? But the invention is first time when you're producing, and then what happens? You put a kind of like Thomas Alva Edison came out with bulb. That was invention. And, it is very surprising that Thomas Alva Edison actually patented it after 6 years. So now whatever bulb we are seeing is not the bulb which Thomas Alva Edison has, invented. So now, so first of it, when you're talking about the patentship, the idea must have 3 features: utility, novelty, non-obviousness. So let me explain each one of this. The first thing is any idea should have utility. Utility means usefulness. And utility is best described as something that has use. Any invention is useful if it produces an effect. A machine which will not operate to perform a particular purpose for which it is meant, it is not called useful. Suppose you make a machine to produce a kind of a soft drink, and machine is not able to mix the mixture with the water or soda and able to produce, then it is not useful. So it should have a utility. In 1790s, I'll just show you some example of that. Okay. So in 1790s, I'm talking about where the people never knew the word called patent. It was actually a process which was very difficult to separate cotton and seed. Seed was embedded in the cotton. So Ellie Whitney was a person who invented a cotton gin machine and obtained a kind of a patentship, but it was not a very legal kind. That was a first patentship for a device that could separate the seed out of the cotton. So you can see that that's on the screen. So if the invention does something useful, you are claiming, then as the basis for your patent, that becomes the basis of your patent, because your idea have utility. It is going to become useful for some business or for the society. So if your idea has utility, but the thing it does is not what you are claiming in the patent, then also it is not patentable. For example, if you made this machine which will separate the seed from the cotton, but if it is a very good idea, it can be patentable. But you developed a machine which is not doing what you're claiming, then it is not patentable. So the useful thing, it does not need to be a thing you claim that it will do that, but it should actually do this. So in addition to having a utility, the second point is that novelty. An invention should be novel. Novel means new, new to the world, new to the market. So let's talk about novelty now. An invention is novel if nothing identical like that existed before. Like if we now come up with a new kind of a technology in the light, then it is innovation, not invention, because the light is already invented. You are bringing some innovation in that. So you cannot patent that. Okay. So sometime when you have a stroke of, some kind of an idea, very brilliant idea, most of the people have, and you think that, you're the only one. But you find out that someone has already invented a similar kind of thing like that. Right. So that doesn't become then novel idea. So novelty means it should be new to everyone. Nobody might have heard about it. Nobody is doing any work on it. And so it is totally a new. Like one of my student who called me to ask me about patenting a new idea. And he was a golfer. And his one of his friend got a back injury. And that injury made that partner of his who was playing with him, can't, that person was not able to bend and pick up the ball from the cup. And he was a very good golfer at a very state level or a national level. He could have gone. He could golf, but the only thing is when he bent over to get the ball, the hurt, the kind of injuries he had on his back was not allowing him to do that. So this student said, ma'am, can we have a set of prong or something that could plug into the end of a putter or end of a stick, and then you can just pick up the ball without bending. Then I told him how to search the patent. Then he said, ma'am, then I said, is it a novel idea? Has anybody thought about it or has already filed a patent on this? So then he said, ma'am, how do we find about it? So I will tell you, I'll take you to those sites and all, and you can find out, because you may feel that it's a totally a new idea because you've not seen any product which does the same thing what you are claiming for. So I told him to search a patent database. So I just simply said, why don't you go to Google patent, which I'll show you now, and search. And after one day, he called me back and he said, there was already a patent, ma'am, which is issued on the exact same thing. And there's a drawing that were almost identical to what I thought, that how I'm going to make it. But so for him, the idea was novel, but it is already done. So it is not a novel idea. Therefore, he cannot obtain a patent for that particular idea. So it's not very difficult to overcome the novelty requirement actually, because there are so many creative solutions to so many problems that most of the people, not necessary that one particular problem is solved by one particular method. That means there is no other possible ways to solve that particular problem in other ways. So you can invent a lot of things in that. And the same, if there is a solution available, maybe you can find out a different kind of solutions which may reduce the cost or which may do something better than what is the existing solution. So the final requirement in the patentability is very, very difficult. The third one, which is non-obviousness. Non-obviousness is the requirement that your idea should not be obvious to other person, skill in that particular area of science or engineering, wherever it is. So a person who is engineered in mechanical and you are thinking something which is obvious for that person, if you're talking to him, okay, fine, this is already the solution, then that cannot be patented. And this is the most difficult part of it. So let's say that there was a ball picker, the same example I'm telling you. So there is a ball picker upper like what my student thought of, but the prior patent used, where when he searched for the patent, he found that the patent used 5 kinds of prong. Prong is kind of a picking up things which will pick up the ball, rather than 4. The patent examiner find it obvious to invent a picker to ping the to pick up the ball, who has already, and you say instead of 5 I will use 3. So if the patent examiner felt that that he or she will issue a rejection based on the fact that this invention is obvious because this is already done, this is already there, but what you are doing is, instead of using 4 arms, you are using only 3 picker arms, or you're doing it with lesser number of arms and a different kind of a process. So the process may be different, but the idea is same, to pick up the ball without bending. So a ball picker, suppose, says, though my student said, ma'am, instead of a picker which just hold the ball and you can bring it up, if we use a suction cup or a spring or a sticky surface, can it work? So it might not be obvious, but even though they all solve the same problem, they do it in different way. So that means that you have a different process, but it should not be obvious to somebody. Like, for example, when you're saying there is a problem, a person who's hit can't bend and pick up the ball, and the solution immediately can come. Okay, can we, have a kind of a picker which has a, kind of a holding hands, and it can just go like a finger and hold the ball, and then you pick it up and put it in your hand. That's very obvious thing. But if you come out with a solution to pick up a ball with a suction cup or a kind of a other thing where you don't require to hold it, immediately suck and you bring up or something like that, then it is an idea, the process is new. Then it is not very obvious. So it is easy to invent something novel, meaning that no one has done that before, but inventing something that is not obvious is a challenging task. So most patent rejections are because of obviousness. When you come and say, for example, one more student came to me long time back, and I actually do it with my engineering, some of the other college professors and all, I show my patent and all to you. So when they were doing, they said that, ma'am, I want to, invent a baby monitoring machine. Then I said, what is new in that? It is already existing. It's obvious that baby monitoring, you will have a camera, you may have IoT or sensors. And when the baby is moving in the bed, you may sense it. It may beep, and or it in the camera you can see. Then he said, okay, ma'am, but can I do something different so that, because what happens in the camera and all these things, the parent in the other room, because in US and all, the law is that you have to keep the baby in other room. So what happens if the parents are need to remain alert, so they can't sleep in the night. So what if I have something where if the parent felt asleep, and if the camera and the sensor are giving alert and they're not able to sleep, so they jerk the parent and they wake the parent up. I said, okay, fine, do it and find out something, but will it be, will the person, if you are trying to commercialize that, will anybody like to do that? Will a parent would like a system where they jerk them and awake them from, because that may cause some kind of a shock also in them, and some people can get even a heart attack. This is what reality I saw somewhere, it has happened. So let's say you invent this, you spend a year showing people, maybe even selling a product that has a lot of invention which you think is useful for the society, but you have not applied for a patent for your invention, then what happens? So your public practice of that invention will bar you from getting. So when you start using a patent, before that only you have to get the patentship. Once you start using the product and you run it for many years, you try to see whether the product is useful or not, then apply for patent, then you won't get. So in a word, in any other word, I want to say that you can be barred by your own disclosure. You should not disclose your patent before you obtain a patentship. So if you don't file a patent within 1 year of the time that you have disclosed the idea to somebody, then there can be a question of confidentiality. So we give this, though normally the law in India give 1 year to you, a safe harbor period. So that is what I'm going to come to now. So safe harbor period in any country, every country, it's a universal law. You get a 1 year time frame to file a patent upon making a disclosure about your invention. In many countries, your disclosure will bar you from obtaining a patent. They don't give you safe harbor period. But in India, including some other country, you have a safe harbor period of 1 year. To summarize that, what we have covered till now: patentably required utility, novelty, non-obviousness. So you can get a patent on something you have made public more than 1 year to filing. So that is what I wanted to tell you here in this thing. Now, why do you want to do a patent? Because patent give you an ownership on your own invention, and it prevent other from cheating, copying your thinking and hard work. So whatever you have invented, at least you should earn some money out of it. Maybe you might have put some funds on it, or you can sell it to a company. So a patent attorney can assist you through this process. You require a patent attorney. I may help you, those who want to take help. I can share my email ID in the end of the session, and anybody who want, they can get in touch with me, and I will share my mobile number also with you all. So in case if you want to take a help on patentship or something like that, I can give you the numbers, and I can help you in collaboration also, because I also work in collaboration. It's not easy because patent filing and all is an expensive thing and require a lot of efforts, which I'll tell you. So you need a help of a patent attorney who can assist you through this process. And these are the people who have specialized in patent law and practice. Okay. So when you get a patent granted, that means you have right to claim damages. That means a patent holder has a right to damage for infringement. If somebody is using your invention without your permission, so you can ask the compensation from that person. So that is the right to claim damages. Then you have right to sales. A patent holder have a right to sell, import, manufacture their invention and all those kinds. Or if you want, you can sell the ownership to title to somebody. And right to grant a license. You can grant, like Microsoft, all these IT companies and all, what they do. They give a right to license for the user to use that, and they pay them royalty for that. They don't tell them the formula or the trade secret, but they take them. So they give them the right to use that. Now we will come to something called patentable idea and non-patentable idea. Which are the ideas which can be patented, which cannot be? See, all ideas are good. We never say to the students that ideas are never good idea or bad idea. Okay. The ideas are basically, while many ideas are just not going to be considered useful or cannot be patentable, that you have to recognize. And so, but if it is not patentable, doesn't mean it's a bad idea. So, like for example, I'll just show you, these are certain ideas. For example, A12 golf club. These are something which some of these things are done by my students, but you can suggest. They've not got patentship on this, so don't assume it. One student has come out with something called diaper alarm. I just was telling you about a little bit about that. That when a baby does something and the diaper set up an alarm on it, then beach boots, and fashionable boots, because beach boots are very non-fashionable, so that a fish bath, a toilet timer, okay, that sometime, all those kinds of funny things, a doggy umbrella, okay, or the instant facelift. So you can tell that by the title alone that these are probably off the wall ideas, but they have been patented. Means at least publication has been done. These are all my students' idea which I'm showing you. Okay, I've seen those ideas from last few years when they file, because we have a full-fledged patent cell in our university, and we encourage students from the first day itself to go for patentship along with the professor. So they had utility, they are novel, and they are non-obvious. These three things are there in this. Maybe it doesn't seem very good idea to you, because who would like to have a doggy umbrella? Right? Nobody will say, why do we need doggy? Why we will not take the dog outside in the rain? And how will need a doggy umbrella? But because these are novel, nobody thought about it, it's useful, non-obvious, has got patentable. So most of this doggy umbrella has got a grant also. Okay. So not every product need to be patented. Many ideas aren't patentable. Some of the company, actually, most of the companies come up with new ideas. They have R&D cells, but they choose not to file patent for their idea because of the cost. because they do not believe their idea will ultimately result in commercialization. So they don't go for patenting. I was reading a recent study that 90% of new innovation developed by the companies are never actually turned into patent application. Think of some of the greatest products that are not patentable. I'll just show you. Okay, so these are the things. These are the products which are great products, in a way are new to the world, but these are not patented till now. So WD-40, Gatorade, first energy drink in the world. Silly putty is one of the things you can see. Cornflake, that was the first time bitten, corns. And Slinky, again, one chocolate was there. It's a kind of a slinky thing. Most of the students like, kids like that. And I don't know, it's a jelly kind. It looks very sticky, but people like that. So as I said that earlier, that recipes are not patentable. But you can imagine that there are many, many great ideas for food products. I actually think that that's why I am saying that. And there are a lot of drinks that are simply not protectable under patent law. So there are many innovative products that are simply not protectable under the patent law, but they might be protected under the other IP law. Okay. Now the question comes always, and this is how my students always, our students in the university ask, what is then patentable? Patentable subject matter includes what? It includes processes, machines, article of manufacturing, or composition of matter. So now, if you see this lit, you may say, oh, okay, then anything is patented. Then why are you saying not everything is? See, while many things can be patented, but there are some things that are simply not patentable because of the subject matter. We don't allow patent on a thing that already exists in the nature, for example, okay, which already exists in the nature, or you are just doing arrangement of the thing that already exists in the world. For example, filtering the water using sand. Okay, this idea is not patentable because in the nature, we all know the sand filter the water. And if you use a sand, clear it and use it and say, I will put a sand and I will put water into it, it will clear the water. It doesn't happen. That cannot be patentable because it is already existing in the nature. It's an arrangement of the thing existing in the nature. Okay. So some more examples are there. Like, for example, data structures or programs. Okay. These are data structures on the program. If you are creating some DBMS or something, those cannot be patentable because these are already existing and you are just rearranging the things. So there are something which programs that can be patented for what they do is totally novel, which no other program can do. Okay. So non-functionable descriptive materials, this I took it from the website of IPO, that cannot be patented standing alone. Program cannot be patented for what they do in some cases. Then then we say some kind of a natural phenomena. For example, electromagnetic signals are considered a form of energy. So it's a natural phenomena. You can't say, I discover it. That cannot be patented. You might have done some discovery. So what I mean to say is that discoveries cannot be patented. Right? So computer programs are patentable only when it is embodied in something physical, such as hardware. Then it can be patentable. Like, for example, 3D printers. Okay. So these items are considered indistinguishable from the abstract idea and law of nature, or are unpatentable. So therefore, once you exclude these things, anything else is fair game in terms of patentable. So we know that you can patent anything, but there are certain things which you cannot, which I have just given you a few list of it. According to section 3 and 4 of the Indian Patent Act 1970, it states that the invention that cannot be patented are the things like which is existing in the nature or the arrangement, just like a few examples I have given you. And so we will also talk about design patent. Somebody asked me about that. So instead of wasting, because this might be something which you already know. So let us go quickly into utility patent or different kinds of patent. So you have utility patent, patent, and plant patent. So we'll be mostly talking about design and utility because this is what somebody asked me. So as we discussed, that invention must be useful with, so that only it means that it should have utility, it should have novelty, and it should be non-obviousness. Then only it can be patent. So so when we talk about design, and we will talk about design patent later in the next slide. When we think about utility patent as a normal patent, okay, the utility patent means, utility word means useful thing. So utility patent is a useful invention that should be novel and non-obvious. That these three characters should be there. And that was not disclosed. Remember the safe harbor period by the inventor for at least for 1 year prior to filing. So there are few types of things that could be patentable, like biological invention of business method, chemical formulas or processes, then computer hardware and peripherals, which is new in nature, computer software, electronic circuits, gaming machines, mechanical inventions like medical devices, musical instruments, new kind, I'm saying. So all these examples we can do. I will talk also about some of the utility payment in terms of companies. So electronic circuit, game, all these things I told. I'll give you some example of the company. Amazon.com has obtained a utility payment on one-click method. What is this one-click method? You may recall that Amazon in early days, when you used to log in into account, you could make purchase and you have to follow a kind of a checkout routine. So 4 or 5 pages of checkout will be there. Now Amazon came up with something called one, and the customer used to get irritated. So Amazon came up with the process of one click. Right. And the one click means you click on it and you already have your saved details on it. You just go to the payment and do the payment. You don't have to waste a lot of time in it. Okay. So similarly, one more patent I will tell you. These are something which they have done, the companies. iPhone. If you know the iPhone swipe, now it is there in all phones. But iPhone came when they came up, they were the people who came up with this technology of swipe to unlock your phone. And this is one of the Apple's patent for the method of unlocking a portable electronic device using gesture. And any other company, Samsung and all, they have used it. They have paid Apple for doing. They have taken permission to do this. Okay. So then again, the Visozone has done a patent for composition of drug called Viagra. Then 3M company came with something called Post-it notes on your desktop. That is also patent. Velcro is also patent. So most of these innovation, I'll not say these are inventions, that have changed the world and made people do the same kind of work in a different way are also patentable. So it's not necessary that it should be a invention. It can be an innovation doing the same thing in totally a different way. Like for example, barcode scanner. That was patented by Walmart. Before that, there was a manual printing of bills. Then barcode scanner came, which scans a product, take the address and create your bill. Now the Walmart has moved ahead and it has come up with RFID. So you don't have to do anything. RFID tags are there. It automatically takes. So when you file, so the question is, utility patent is not so easy. You have to find an attorney who can tell you whether this can be patent or not. Because in India, there are a lot of help available, unlike in any country. So when you are choosing to hire an attorney, the attorney will do everything for you. They will do even the patent search for you. They will try to guide you to modify. They will get you collaborators. They will get you even fundings for that. And they will help you in drafting and filing your patent because they know the patent law. and they understand whether this idea is good. But if you present in a certain way, it cannot be patented. So so it is now we're going to talk about the designing patent about this. Okay, so you in India, you either have to hire a patent agent or you have to. So you personally, when you contact, I'll give you some numbers and you can contact them. They help you in doing everything. They help you in collaborating with the others and getting and all those kinds, right? I'll give you the email ID of those people, and public attorney also. So they will charge you. Even nowadays, it is not very difficult. You don't have to pay. If you have an idea, you can come up and make a group or community of some people who all can do work on your idea, and all of you can collaborate and pay money for that. That's how these nowadays the patent is working. Now, somebody was asking me about design patent. So how do you obtain a design patent? Again, you should have the three things: novelty, utility, and non-obviousness. So again, you have to see that the design is not a copy of any other design, or there's no similar design available. This means that, and also you have to file this within 1 year of your own publication of the design. So like utility patent, design patent also should have utility, novelty, and non-obviousness. Design patent must not be obvious in the light of that somebody, suppose some in history, somebody might have painted something in the form of sculpture, and now you are putting it as an idea in papers. So that cannot be patented. Okay. So it should be totally new. So you are only obtaining protection of in design patent, you obtaining the protection on the ornamental element of the product, not on the functional element. So design patent cannot be obtained for the design functioning. It is obtained on the designing functions. I'll give you some example and you'll understand. So the goal of design patent is to protect the design, aesthetic design of the thing, not the function. So many machines which do not have a non-functional aspect or they're not patentable, but many machines, like even the clocks, iPhone, the watch, which was there on the iPhone. So US, in Europe, one country actually had the same design in the railway station. So Apple filed a case on them and said that we have obtained a design patent on this. So you cannot copy the design of the watch. So they can see watch functions can be similar, but design cannot be similar. So you're obtaining a kind of a patentship so that nobody can copy your design of the product or whatever you are doing. So that means that it should be an aesthetic two thing. So utility payment and design payment is subject again to the examination under the Indian Patent and Trademark Office. So they will also do something called art search, which I'll show you now. Design patent has a term of 14 years, whereas utility payment has a term of 20 years. Protection. 20 years you can have patentship on that, but design will have 14 years. So there are many things that can be patented as design, including cloth accessories. Okay. So you have accessories, jewelry, furnitures, beverage containers, textile pattern. So it will just protect the design aspect, which is non-functional, unlike in utility. So some example of the design patent I'll show you. In 1842, George Bruce was the first person who was granted the first design patent under US patent. The design patent was about his new font. You can see this new font. He obtained a patent on this. Strange, right? Then in 1879, Frederick Bartholdi was awarded a design patent for the Statue of Liberty drawing which he made. Okay. And Apple also obtained a design patent for the basic shape of iPad product. But there was a lot of debate about the Apple iPad shape because it was not novel and not obvious, because it is a rectangular kind with a, not with a sharp edge, but with a, a narrow edge or with a blend edge. So there was nothing new in that, but still they got patent on this. So one of the most useful way to actually see the design patent is to prevent, why do people do that? Prevent counterfeit. Let me explain. If you have a product, maybe a unique spatula or a tool or an exercising device, you can get a design patent for the device even if you cannot obtain a utility payment, because maybe the design is very unique. So if you get a design patent but not a utility, then you cannot stop someone from creating their product with different design but same purpose. So however, the design patent, you can stop them from making the exact replica or design of yours. So take a unique kitchen product, something like some kind of utensils. You cannot stop people from making those utensils. But if you have created a special design utensils, you can prevent someone from using the same design for the same kind of utensils with a design patent. So if your factory is selling your product without your knowledge, then in that case, you can just go ahead and you can just issue a copyright design patent on that. So design patent is similar to copyright. There's a slight difference in that. So some firm charge actually, just like I told you about, this thing. So how do you do that? I will just take you to the Google patent site and I will show you the drawing of the components. So when you look at a patent, you will also either, you can go ahead when you are having any idea, go for a patent database. Google patent also you can go and see whether the similar patent exists or not. Okay, so you can go to google.com/patent and you'll find all kinds of patent. And when you are applying for a patent, it will be helpful if you go to the site and search that how patent is published, what is the document, how it is feeded. Okay, and how application are filed, how designs are made, what are the requirement. Okay, all those kinds of things you can see there. So I'll just take you to the site and show you. Just give me a few seconds. You all can see now. Okay, so now let's say you want to make, let's say you have an idea of electric massage chair. I'm just randomly putting anything. You have an idea that you want to search for an electric massage chair. So go to electric, you can see that so many are filed already. This will show you everything. So I just click on this, one of it. Now you can see here the number. It is filed in China. Okay. And who is the inventor? It is written in China, Chinese language. Application filed by this person. The number is this. Application is, this is also granted. Publication and all these things are done. Date is also written. So for 20 years, you can't have the same patent chip. So you can see that how it is filed. So you have an abstract. Abstract is always written in the end. When you have the abstract, is the summarization of your entire invention. Then you have a description here. You can see technical background of the technology, utility model. Okay. Then in the description, so you can just go and see how the patent, file and documents are made. Then drawing and explanation. So you can see here the drawing also will be there. Okay, I'll just show you simple one. Now you can see here. So you can see the abstract is there, the images are there. You can just elongate. You can see the image here. This is the design, classification, description, okay, technical background study. Why have you done? Why did you, what is the useful of this? Whether there was a, literature review done or not. Summary of the entire chair, the all entire research you have done. So this is before you making a prototype, you have given this brief description of the drawing, what drawing you have given. You given a description of that. Then you have detailed description. And then it goes in pages. And in the end, you will have references that what are the research you have done from where and how you have compiled your idea into, your research. So there's a lot of research which is needed. So I'll just go here and I'll show you. See here. So this is in 2018. This idea was in the US. The application was filed on these dates. The dates are given, and the application is granted, and it is still active. The status means you can't do this. When it is written, it is passive. You can do it. And citation, claim is very important. What is claimed by these person? See, whatever you are getting patent, you have to claim something. That my product or my services or my process is going to do this. And those claim is made. So here 30 claims is made. Now each claim is described here. You can see that. All 30 claims are made. That this chair is going to do these 30 things. Okay. First thing, if you read here, it says electric powered chair, assembly control. The system comprises a control having at least one chair actuator output and at least one chair heater output. So all these claims are made over here. You can download the PDF. You can see. So all kinds of description, because it is already granted. So even if the description is given and you say, oh, I will copy, and without their knowledge you are doing it, then it is okay. Otherwise, you can't copy. Okay. And commercialization, because under the law they are protected. Patent means what? They are protected from infringement or somebody copying them. Okay. So let's now see what is a process of patentship in India. So let's go ahead and see. Now, if you want to do patentship, there are two things which you can do. Either you can apply for patent in India, okay? And you can directly apply in India if you are India through an agent or attorney. There are a lot of agent and attorney available. And if you want, otherwise, the patent made in India, suppose if you have done the patent in India, but you want to apply in international, in certain countries. But though you don't want to apply in India, you have to India require you to file any patent which is done in India, the geographical location. Or else if you want, you have to obtain a permission to file the patent in some other country. Now, once you file the patent in India, what they do is they basically check all the formality, whether it is compiled with or not. And when everything is fine, whatever you have to provide, I'll show you my patent, then it get published within 18 months. Publication doesn't mean your patent is granted. Why they publish it? So that if there is any third party who has already applied for that patentship, they can come with opposition. For 18 months, it remain published. After 18 months, the applicant should go for the examiner asking for examining. So there will be a patent examiner from the government who will be appointed to decide whether to accept or refuse. If the patent examiner give you, suppose if you accept, then your patent is granted. But if it is not accepted, suppose they reject it or there is a negative thing, then the applicant again can apply within 6 months with a counter file argument. What if you want to have in several countries, then you can go to the patent cooperation treaty, which is the best option. But before applying for any patentship, there is something which you must do, which is called patent search. You have to find out whether your patent is novelty or not, has novelty or not. So let me take you to a site, and I will put this in the your chat box also, so that when you are doing anything, before you go ahead and do a lot of things, you can actually see this. I'm just going to put this and I'll take you to that website. So how do you do patent search before you file or before you go for application? Find out in the patent database whether it is done or not. And whatever patent you're filing, suppose in India, it is protected in India only, not outside. Whichever country you're filing, it will be there in that particular country only, it is applicable. So I'm going to, can you see the WIPO site? Anybody can tell?
Yes, ma'am.
Okay. So this is a site of the World Intellectual Property Organization. It's a universal site, and it has a global database. You can go to patent scope and search, and you can search for anything. Let's say I will do electric chair, and I'll go for search here. Let's say I'll go for here, any field, electric chair, you go for search. Then you see there are a lot of research which is available right here. So I just do here. When you see there are a lot of things which I can do. Here it is all the offices. So what I do is I go here and check for the offices in India. If I want to search in one particular company where I'm applying. So I'll go here and put a tick in India, whether this is patented in India or not. And then go for search. You can see now the office, or it is searching only in India. Language, English, all those things you can do. So you can see here. So this is one standalone solar powered electric dental chair for rural healthcare application. Somebody has filed an application, so you can just go on it and you can find out the detail of that. So this is a universal database. So every patent, when you're filing, it should have a title. See here, it is patent in India. Application number is given. You can go to the government site. I'll show you that. Application date is 2021. And I think this is one of my colleague who has done this. So that's why I remember this. And see, yeah, Dev Nayan. Yeah, I know him. So applicant inventor is given here. You can see here. Abstract. So in WIPO, you get only abstract. No, you have abstract. You can go even for description little bit over here. And also you can see, because you need to have a claim also. What is a claim you are doing? Okay. And then the documents. So maybe sometime the these documents and all these things. So whenever it is granted, it will come into WIPO. So this is one way to check, right? To check about your own thing. So now I'll just go ahead and finish few things more. I'll just talk about the process of filing applications and all, and then I'll show you a sample of it. Okay. So what's the procedure of filing a patent in India? So the patent in India, as I said, it can be invention or innovation. We discuss certain example of it. So patent registration process is the one where we have to follow certain steps. First thing is, if you have searched, first thing, whenever you have an idea, work on it, develop whether it can be developed technically into a product or process or not. Then do the patent research before you go ahead with the work and find out that if somebody already has filed a patent on that, or is it available or not that. So you can go to Google patent or patent scope in WIPO and find out that. Then after that, suppose if you found that your idea is novel, it has utility, and it is non-obvious, then you can go for filing the patent application. So the first thing in the patent registration process is filing a patent application. You can nowadays go for e-filing on the government website. I can show you the website also. And you can choose to file a physical copy also on the Indian Patent Office based on applicant location, wherever you are located. So there are 4 Indian patent offices located. One is in Delhi, other is in Kolkata, Mumbai, and Chennai. That means 4 metro towns for patent registration. And these organizations, these places or location offer the facility to get the patentship. So it is physically, if you're filing through attorney and all, they will do it, go to the office and do all these kinds. So now, firstly, it is very important that when you're filling the application, there should be no error. Otherwise, your application immediately get rejected. Then it's very difficult. So for patent registration, application should contain some specific information, like your name should be correct, nationality, type of application, address of applicants. Suppose it's given by a group of people, then inventor's name, the other details. So you have to understand the process of patent registration. For that, best is to hire an attorney who knows about it, because they will correct it for you. They will do everything for you. So understanding what kind of a type of a patent you're applying for. Right. Now, I'll show you in the other slide also, there are different kinds of patentship you can apply. You can apply for provisional or temporary patent application also. Or you may apply for a permanent or complete patent application. So provisional and temporary patent application is when you are still in the research and development stage. Your idea, you have not developed any product prototype. You are doing only research. At that time, you apply for provisional so that no other people can do it before you do it. Okay, so you get a time period for that. Okay, and it has a lower cost. You get 12 months to come out with a prototype of your products. So complete patent application will have when you have already developed the product, which will include your background study, abstract, detailed description, design, drawing, claims. I just now showed you all these things. And it has to be in a prescribed manner. So you can file a provisional patent application, or you can file a complete patent application. After filing a provisional patent application, within 12 months, you can file a complete, but by that time your product should be ready. Second step is publication of the filed patent application by the patent office, which I told you. So according to the patent law, post patent registration, this is registration you have done. After registration, the patent application is published for 18 months of filing, and this will be available on the Indian Patent Office database. And this is a process which is required so that any third party can oppose and say, no, this is my work and somebody has taken or cheated me, or taken my work and representing as their work. And these data, this publication is available for all. So anybody within that 18 months, if doesn't claim that it is their invention, then you can go for a third steps. That is filing a request for a patent examiner in the patent office. So, and you have to do that. It is not like after 18 months, automatically it will happen. You have to pursue them. So for patent registration, the examiner of the patent application, as I said, is not automatically done. You need to send a request for examination. So patent applicant can file for examination of patent application after 18 months of the period is over and nobody has challenged your application. Right. So if it is a startup company, you have an expedited process also, which you can do. Then the fourth step is patent registration, either granted or rejected. Once the patent application fulfill all the formalities, overcome all the claims, what they have done and prove it, the registrar or the finally give the applicant, and it comes into patent gazette also. And 20 years of patent is then granted and registration is done. You get a certificate. Okay. So you can do that. So this is a process which I was telling you. These are the type of application. I told you provisional application, which is a temporary application. For example, your invention is still in work. You are still in the research. You have the idea, but you have not developed the product, then you can go for. But within 12 months, you have to come for the complete or non-provisional application, which is when your product is fully developed. Okay, complete application. Then there is something called, direct filing. Direct filing is nothing but complete specification. When you have developed the product, you have used it also, you find it is useful, whatever you're claiming is being done by the product, then you can go on machine or whatever you have done, you can go directly for the filing and your process will be a little bit faster. Then subsequent filing is when your product is developed and you make some modification and say, okay, one more addition we are doing in that. Then you have something called convention application. In convention application, the date which you have filed, in the same similar application you filed in some other country. I told about treaty and all. So Indian patent office you filed, within 1 year you can file in same patent in another country, even if it is not granted or granted. And there is something called PCT international application, which is also international patent grant, but you have to take permission. You want to do it, not do it in India. So you have to obtain a permission from India because you have done the invention in the land of India. Okay. So multiple nation, that is also called multiple nation patent granting. Okay. 142 nation is there in that is called Patent Corporation Treaty. You can go to Google and type that and you can file application, but you have to take a permission and upload that. Okay. So these are the things which you have to do. What are the documents? A lot of documents required. I'll show you. There are a lot of forms. You have patent registration form 1, 2, 3, like so many are there in the provisional specification. You have from form 1, 2, 3. So many forms are there. Every form has different. Then you have the official fees and all those kinds. Then where to file, as I said, that you can physically go to these 4 metro towns, Chennai, Delhi, Mumbai, and Kolkata, and you can file with an attorney over there, physically form. So it depends on which particular city you will file. If you are residing in the south, you can go to Chennai. But if you're residing in the Delhi and all those Haryana and all those places, you have to go. So the places you will have the all detail there in the website. So you can just find out the city which you reside and in which jurisdiction it falls under. So for the applicant who is non-resident and has no, non-resident Indian, for example, and they want to file a patent in India, can they do that? They can also file it because it is allowed universally. You can file in any country, but you are not domiciled. Then what do? Then you can go and file in Calcutta. So Kolkata, for any place, if you're not belonging, you can go to Kolkata and file that. Okay. Then there is, nowadays nobody goes for physical, everybody goes for e-filing. Right. So patent filing process, all these already I told you. Right. I'll not go detail into this. Now, what is the cost? Very important. Most of the people don't file patent because of the cost factor. Right. Everybody, if you go online and try to search, you will find different type of cost. There is no fixed cost which anybody can tell. So at different stages, you have different cost. Right. For example, patent drafting, there is a cost. Examination stage, there is a cost. When you're receiving grant, there is a cost. Right. So how do you invest and save money? Because it's a huge cost. Government fees too are actually different for individual inventor and a company. If you're an individual inventor, there's a different fees. If you're a company, there is a different fees. So the patent application cost or the fees differ based on the number of claims and pages in the specification. Lot of factors need to be considered before you decide the cost. So there's no fixed cost for it. So if you have to give you a rough estimate, a patent in India will cost you around 45,000 to 65,000 in all stages before you get a grant. So, because you have to anyhow hire a patent agent and attorney, and they will also charge you some fees. Sometimes it may go beyond 65,000 also. If you go to the website of iFlare and all these people who make the claim that they'll do everything for you, they may even charge 75,000 to 1 lakh. Okay. Now, there are a recent update in the patent rule in 2021, which is a regulation, which says that 80% reduction in the fees for patent filing and prosecution for educational institute. That's the reason every educational institute now has, most of them, those who are universities, they have their own patent cell. And many corporates tie up, or individual people tie up with the university, because university name comes and university get a good accreditation. They tie up with the university, collaborate with some university professor, and the educational institute go ahead and file the patent in which their institute name is also happening. And also in this process, the grant is also faster. And whatever you're paying, there's a reduction in 80% on that. Okay. So it is more faster, like in 3 to 4 years, you will get the grant of patent. Or in some cases, even I've seen it is 1 to 1.5 years. It is so fast. I've seen one of the patent which was granted to Chandigarh University. I am in one of the group of the professors all over around India. And somebody said that they got a grant in 41 days. That's a kind of faster educational institutes are getting. There is also some category of people who get special, treatment, like women applicant. I already told you about educational institutes, startup companies who has got grant from government, SME, small and medium enterprises, government department, institution established by central and government company. So patent attorney fees for patent drafting can range from 10,000 to 30,000. Which is like everything they do it. Some may charge more because they do A to Z for you. You just need to have idea. They will draft the patent application for you and they will do everything for you from the filing to getting grant. Okay. So Now I will just show you my patent cutting, so you will have some good idea about it. Okay. So there are various kinds of forms you have to fill. I'll just show you. So this is a form 1. So this is an application for registration. This is the application which can be downloaded from the the website. And if you can see here, these are all my, you know, the people with whom. This is my name, Anita Walia. Okay, and this is done long time back. So this is like 3-4 years back. So this is a normal invention. Now the title of the invention was wearable electronic monitoring of body parameters. This is before COVID we did this. Okay, so you can see the main inventor name, and this is the company in Tamil Nadu who has supported us. Now I filed through my university. That time my university didn't have this. So there are a lot of groups, academic groups in this in which I am in. So one of the group, we basically share our idea and collaborate, so that we share the fees also. See here, the patent number and all these are not applied because it's in a filing case. So all signatures are there. You can see here. So this is a form which is filled, and see how many number of claims are there. So at a time of registration, we the government charged only this much. Now it is a little higher than this. So 7 claims were made. Only 1 page is there. Depends on, now there was no drawing and number of pages because we just filed the case. Okay. Then I'll show you the form 2. So this is the form 2. So complete specification of the patent is there in the form 2. The title of the invention, the name of the inventors is my third name. The main inventor is this. So Dr. Danish is there. And so he's from the University of Mumbai. So we collaborated and we came out with this. So there are so many people who are there. So complete specification, see here, abstract, background of the problem. Then it's like a research paper. What is an innovation model? Then you can see here, this is a simple drawing. Then how from the device you can monitor the various kinds of, it's just like a wearable device nowadays. So summary of the innovation. These are the claims. So we made around 7 claims that it is going to, what it is going to do. You can see here. So this was the second form. Then the third form you can see here. So the statement and undertaking, you can see all the names of the inventors. And he's the main inventor, so his name will be there always as the first inventor. And then we had form. So this is patent e-filing. If you see, this is the fees we have paid, 8,200. This is the receipt of that. So you can go to IPI, this particular website, and you can file this. And I'll show you. This is the form 5, name of the applicant, inventor's name, and declaration. And then the form 9. Now we asked, we again after filing, then we filled one more form for publication, right? So this is a publication which you can see now, which is already published. So there is a number which will be given now here. And through that number, we can just see. So dated and all these things are there. I'll just show you. This is declaration. This is form 3. This is form 1. This form 2, which I've shown you. This is a receipt, and this is a full description and the claims. Now this is already published. So I'm going to just show you one more. Just give me a few seconds. I'll show you one which is recently in the granting stage, where it is a design patent. I'll show you that. So it's basically a network security device. Okay. So this is the thing. Again, this is the idea not by me, but we have collaborated together and done this. So this is a design patent, what I'm talking about. So you can see here. The design application number is given here. The design is also given, and it's called network security device. We have not gone for utility payment here, utility thing here. This is a front view of network security design thing. This is a rear view. These are our agent signature. These are all the applicants. This is the left side view. This is the right side view. This is the top view. From every view we have given, you can see the bottom view. So this is the one. Then this is the application for registration of design. All people names are there. Name of the design. Design is applied. We are not giving any name. The design equipment name we have given, and what kind be the design. So we are just going for a design patent here. So I have actually 5 patents. One is already in the grant process. It's not been done, but within few days we will get that. And one is design patent, and one more is there. So 2 more. So 2 are in process, and 2 are published. So I stop here, and I would like you people to. We have few more minutes. So can you people, any one of you want to say something? I would like honest feedback from you all. So please feel free, or if you want to ask something, anything. So let's have 15 minutes of interaction, 15 to 20 minutes. Anybody who would, or who want to give me a good feedback about how it was, how can, what did you learn? Did you gain something out of it? Or do you want to speak about yourself or something? Please go ahead.
Yeah, good evening, ma'am.
Good evening, sir.
Good evening, ma'am. Chandrakant here from Ubli KTC.
Yes.
See, ma'am, we have gained a lot of knowledge regarding the. See, actually, we are new to this IT technology terrain. By attending your sessions, we have been acquainted with the technology terrain and many of the technological concepts which we are not aware before joining the course. So, by attending your sessions, many of the concepts, for example, dark web, which we were feared to even check in the Google. That concept also we have become much familiar with, and we can make use of that now. So it's not a bad thing. And other than that, cyber security and all those whatever topics we have discussed across these 4 months. So they are very much. They were very much interesting, and they have become part of our IT and technology terrain knowledge database, ma'am.
Thank you so much, sir.
So that way it was quite
Yes.
good one.
Please go ahead with certain kind of research. Whenever you have something interesting in your mind, do a lot of, see, every knowledge comes from research. Then if you have researched a lot on something and you've get a lot of knowledge about it, go for publication. Today only morning, one of my colleague in my office was talking about a research she's doing on CBDC. I don't know whether you people have heard about it. Yeah, few session back, again, yesterday also we were talking about Bitcoins, but the government has now recently, all bank has launched it. This is a CBDC where you have virtual money now. So instead of now in wallet, what you used to have is that in the Paytm and all, you have money you spend. Now what you can do is you can have a virtual note of 100 rupees, 50 rupees and 10 rupees. And you go, you spend 50 rupees out of it, you get 50 rupees back from the shopkeeper, but not the physical note. It will be a virtual note which will get transferred. So those are the interesting concept which is coming up in the society. And these are the concept which is not the concept which the government is thinking. It is people like us who are coming up with this. That's the reason we always keep on telling students that if you have idea, try to explore that idea, come with a publication, research, publish it. And whenever you publish something in a journal or you record some even YouTube video also, you never know that what kind of opportunity will be there for you because of that. Thank you so much, sir. Thank you for your honest feedback. Anybody
Thank you.
else?
Thank you, ma'am.
Good evening, ma'am.
Good evening.
Ma'am, I have a doubt on this patent, right?
Yeah, please tell me, Meghna.
Ma'am, we introduced like fly ash bricks in our village. So
Yeah.
can we take patent on that? Like we are the first person who introduced that in our village.
So,
Uh,
so what you can do is in the chat, I'm going to, write my number. Okay.
okay, ma'am.
So what you can do is you can just send me the idea on this. I will research on the patent database. Okay.
No, not like that, ma'am. It's already introduced in some cities, but we introduce same method in our village. So can we take like selling patent, right?
No, no. See, if you are an inventor of it, then
Okay.
you can go for it. And if it is already patented by somebody, then you can't.
But like in if you take like petrol bunks will be there, no, ma'am. In some radius, no one should keep another petrol bunk. Like that, can we take some
See,
patent?
patent is only when it's totally new. Nobody is using, at
Okay.
least in India. And if you say, no, in my village, nobody is using, then it is new for my village. Then it is new for the people.
Yes, ma'am. It is new for our village only.
So that cannot be patent because it is already existing. You are just using first time in your village.
Yes,
That
ma'am.
you can't patent for it. But if the same thing you do it in different way,
Okay.
you say, okay, existing method, use petrol, suppose, but I will use natural gas or solar power and do the same thing, but process differ, then you can go for patent.
Okay. If the
Utility
process
will
is
remain.
different, means we can take patent.
Yes. You have
Okay.
to find out the new way. Suppose you say that it will have the same utility, but different process, different way of doing it. That
Okay.
you can do it. Okay.
Okay, ma'am. Thank you, ma'am.
Anybody? I'm writing my email ID also, students. I just want to tell you all one thing that I found your batch very talented and very hardworking. And there's a huge interest in you people in learning. So, we are living in a generation where the learning doesn't stop. Even we earn, we have to keep on learning, just like doctors. The lifelong learning will keep on happening because technology will keep on adventing. You have to keep on adventing yourself. And today it is not very difficult because all online courses are available. I also gain knowledge from there. Why to tell lies? There are many, many ways you can gain knowledge. Not like our time where we had only one source of information, our teachers, trainer, or books. But today you have information everywhere floating. Most of the thing you can learn from YouTube today. You don't have to even pay to anybody to learn something. But there should be a passion, there should be an interest in it. I have one of my student who has become now a very big producer in Kannada movie, and his parents and nobody in his family was any from the movie background. He didn't have any money, or he was not so rich also, but he learned cinematography from YouTube. And he made few pictures, few movies, few feature films, and he did in college, and he won certain kinds of inter-college competition, and from there he didn't stop, and today he is producing big movies. So these kinds of things are happening around the world, where your learning and knowledge is everything. We are living in a knowledge world, knowledge economy, and if you are knowledgeable, you can make big for yourself. And that comes from patent, publication, research, lot of learning, gaining knowledge, attend lot of seminars, attend lot of conferences, network with people. Best asset is networking. Today, I have earned, or I have learned so many things from students, network of students, network of professors all around India, some professors from abroad. IITs, MIT, Stanford, all these people have group. We made those networking. Even in any industry, you have to make network. If you meet somebody who is from a good company or from a good, background, have good knowledge, take their card, ask for their email ID. If they're not giving their mobile number, stay in touch with them. And these people will help you a lot, not in terms of giving you money or doing something, but giving knowledge. And that is equivalent to earning money. From that knowledge, you can earn money. So that is how I'm saying networking is very important. Networking with the same kind of students is also important. You people have come in group, and don't talk to each other in informal way, or just make a kind of a gathering only for informal or having fun. Have a gathering which should go a long way in creating a network. Somebody can help you. Narayan Murthy, when I was sitting next to somebody, or maybe Sundar Pichai, from a very, very formal background, nobody knew that Sundar Pichai is going to become a CEO of Google or the Alphabet company. So you never know a person with whom you are networking, or with whom you are collaborating. That person may become so big. So why not? Don't consider anybody that. Don't underestimate anybody. So many things I've learned from my own students. I cannot tell them that, you are my student, I've taught you. How can you teach me? Because they have gone into the world of work and they have learned so many things. So anytime when we have a session, or even I'm taking a training session, I've done a lot of training session for corporate also, where if I don't know anything, I just, without hesitation, I call one of my student, if I remember, those who might be working in US, or you might be working JP Morgan Chase, or they might be working in Deloitte or any other company, and I will call them just without hesitation, and I say, can you please help? At least if they can't train me or teach me, they may not have a time, but they give me a link. They give me where I can find proper, correct information. And most of this 5 patents which I filed, and one is almost in the granting stage, these are not my ideas. I'm very honest to you. These are the ideas by some of my colleagues who are in different universities. But because I'm in their network, they asked me personally that can I be a part of it? But then there should be a contribution. The contribution not always come in the form of money. Though, yeah, we all divide and give the money. But the contribution also come in the form of talent. That how do you contribute to that? So you all come together, make a group. If you have any idea, I don't know, your only center, one of the center, I don't remember that center. Such a nice idea they had. I even discussed in my university in the patent cell. I went and I discussed, it's about some snake. I don't know which place it has, Karakala or something, Karkala, some place which is invested with snake. And these people came with an idea that you should have a sensor or IoT device. They have sent me a document also on that from research they have done. They wanted to come with a device which will sense the snake within 2 kilometers and give you an alert, maybe on a watch or something, because there are a lot of people who die. They've done so wonderful research. They have come out with the idea that how many people die every year because of snake bite. And especially this area where they told me actually that this is the area infested with snake. And so many people die before they go for treatment, they die. So there are two concerns and challenges. One, that you should know the snakes, that the snake is present in this area. So you should be alert on that. So you're not bitten. Prevent that biting. Suppose in case you are bitten, then what do? Then in that case, if you're alone, how do you send alert and somebody come for your help? Or how do you, and if somebody is there with you, how do they find out that where is the nearby hospital and which is a nearby medical shop from where you can get the medicines and all? Such a nice patentable idea they had. I don't know what happened. It remained idea only. Most of the time, this is a problem. Some idea remain idea, which is such a wonderful idea. And there's a huge scope that it can be developed into some device and can be patentable, and it can help society so much. See, any kind of research, patent, or anything you're coming up, students, it should have an impact on society. Then only it has utility. Yeah. Anybody else? No? So I had a wonderful time with you all. Okay. And
Ma'am, again, Chandrakant from Hubli, ma'am.
yeah,
So thanks for spending your time and valuable knowledge with us last 4 months, ma'am.
thank you so much, Chandrakant.
So advance wishes of Guru Purnima.
Thank you. Thank you for
And also wish you lots of health, wealth and happiness, and best wishes to all your future endeavors, ma'am. Thank you, ma'am.
thank you so much. And thank you for all your wishes. This is what
Hello,
is,
ma'am.
this is something which we, you know, always remember more than money, more than anything else. It is these kinds of honest wishes which make us, you know, go and, you know, take up these kinds of project. Yeah, somebody else was saying something.
Hello, madam. I'm Vinayak here from Ublic.
Yeah, sir.
Yes, you are giving very good knowledge, ma'am, because we were watching movies and TV news. They were told they did because of that dark web. They use the technology, but we don't know. They use that technology, how they are using. We don't know about the knowledge. You are sharing that knowledge. We got the knowledge, ma'am. Very good knowledge. You are from I got, sir. Okay, I got, madam. Thank you, madam.
Thank you so much for your appreciation, sir. It matters a lot to me.
Thank you, ma'am.
Thank you. Yeah, anybody else?
Hello.
Yeah, hello, sir.
Good evening, ma'am. This is Gaurav Prasad from KTC Hubli.
Thank you. Yeah, sir. Tell me.
Yes, the knowledge developed by you, it's excellent and prodigious one. And being the education background of engineering from past decade, it is again the one of the synchronizing and synergetic experience that we have. And you gave in-depth knowledge in detail. So no way we can expect such kind of knowledge, and you have been given so thorough. So we are so much of thankful and indebted for your excellent support from your end. Thanks for your.
Thank you. Thank you so much for your appreciation, sir. Stay in touch, all of you. I have given my contact details in the chat box. Please, whenever you have any help to come to Bangalore, or in case of education also, if you want your kids to get, you know, admission in Jain University or something like that, try to approach if I can be any help to you. Networking, as I said, is always very important. So you can stay in, maybe someday you may help me or I may help you in some other way. Yeah, anybody? So, okay, then thank you so much, all of you, for patient listening to me. And I hope I was, you know, useful in some way, and I may ignite some kind of a, you know, knowledge acquisition want in you, that you want to further explore, like some of you said about dark web. So I just have touched the tip of that. Maybe you can go ahead and do a lot of research on dark web, and you can come out with good invention or maybe you can work in that particular field and you can understand that the dark web is not so dark as we think. It is all lighted up, but the only thing is we don't have any knowledge and we don't know that what is existing in this world. That's why I feel always it is bad. So all the best to you, all of you, for your future endeavor. Please stay in touch, and all the best for whatever you people are doing. If there is any help required or anything I can do, please get in touch with me. You can send me a message. Maybe most of the time I don't pick up the call from strange number, but if you message and tell me your number and all, or your name, I may respond to that. Okay, so all the best to you all. Okay, I had a great time with you all.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am.
Thank you so much. Bye.
Bye, ma'am.